our topic today is going to be taking a look at how is the U.S. Supreme Court structured and how does it operate. And so while you're watching this presentation, I want you to ask yourself three questions. First of all, it's been 155 years since the Supreme Court has been changed from the 9-member size. Should the size be changed at this point? Question number two, is the U.S. Supreme Court partisan? Do they practice divisive partisan politics? And finally, number three, is it possible for someone who's a pervert or a criminal to be named to the U.S. Supreme Court? Now, as you watch this presentation, I want you to keep those three questions in mind and see what kind of an answer you can come up with. So now, let's get started. What you hear is a gavel in a courtroom in the United States. If you're lucky, you'll never hear that personally. But it's an important part of our system, and we're going to take a look today at Article 3, the Supreme Court in Review, from Judicial Selection to Current Cases. First of all, here is the Supreme Court today, called the Roberts Court in 2024. So who are they? Well, first of all, there's Chief Justice John G. Roberts. The second in seniority is Clarence Thomas, followed by Samuel Alito, and then Sonia Sotomayor, Elena Kagan, Neil M. Gorsuch, Brett M. Kavanaugh, Amy Coney Barrett, and the most recent nominee or person named to the court is Ketanji Brown Jackson. The Supreme Court itself is the highest level in the national court system. They have original jurisdiction in limited cases, but most cases are appealed through certiorari process. That's what you're going to hear about in the news. The Supreme Court is made up of 9 justices. Then next to them is the Court of Appeals, an intermediate level in the national court system. There are 13 circuit courts. They have no original jurisdiction, only appellate. The cases are heard by a 3-judge panel and occasionally by the whole group of the appeals court. The district court's the lowest level in the national court system. 94 district courts. They have original jurisdiction in most cases, and a single judge presides over a case. Framing questions for our presentation today. What is judicial review and where did it come from? What is judicial independence and why do we have it? How does a case get to the Supreme Court? How does the judicial nomination process work? And how does a justice end up on the Supreme Court? What's the difference between judicial review and judicial supremacy? And what are some of the important debates about judicial power throughout American history? First of all, the constitutional courts, called regular or Article 3 courts. Federal district courts created to serve as federal trial courts. They have original jurisdiction and are the principal courts of the court system. There are 650 judges handling about 300,000 cases per year. 80% of the federal caseload. They hear both criminal and civil cases. 94 districts. In the beginning, with the Judiciary Act of 1789, there were 13, and today it's been expanded to 94. 2 kinds of juries. There's the grand jury, which hears all kinds of evidence and tries to decide if there's enough there to warrant a trial. And that's when they do that, then they issue an indictment. Most of the trials that you'll hear about are petit juries, where you actually hear the trying of defendants, and normally there are 12 on a petit jury. Constitutional courts. The Federal Courts of Appeals, created in 1891 by Congress. There are 13 judicial circuits, 1 appellate court in each circuit, 1 court with national jurisdiction. A panel of 3 judges hear each appeal. Very important case. If it's a very, very important case, the judges may sit in what's called en blanc, which means as a whole, rather than just 3 justices. They may uphold the original decision. They may reverse the decision, or they may send the case back to be retried again if they think the evidence needs to be considered in a different way. The United States Circuit Court of Appeals for the Federal Circuit hears cases from Federal Claims Court, the Court of International Trade, the United States Patent Office. Constitutional courts, the Court of International Trade, based in New York, but may listen to cases involving other port cities such as New Orleans, Houston, and San Francisco. Mainly hear cases involving tariff issues. Legislative courts, the United States Claims Court, the United States Tax Court, the Court of Military Appeals, territorial courts, the courts for Washington, D.C., the Court of Veterans Appeals. These are courts where one does not serve the whole life, but for a fixed period of time. You'll notice in this chart that shows all of the different kinds of courts, the arrows all eventually point to the U.S. Supreme Court. Not all cases go that far, but that's where they would ultimately wind up if they're going to go anywhere. Federal judges are appointed for life. They're nominated or appointed by the president. They have to be approved by the Senate. They may be removed through impeachment, although fewer than 100 have been removed that way throughout all of our history. There are 890 authorized Article III judgeships, 9 on the Supreme Court, 179 on the Courts of Appeals, 677 for the U.S. District Courts, including the territorial courts, 16 on the U.S. Court of Federal Claims, and 9 on the Court of International Trade. They are all extended senatorial courtesy. They're treated with great respect, and their pay is set by Congress. This is an actual picture of the U.S. Supreme Court chamber. As you can see, it's quite austere, quite intimidating. There are really not very many seats in there for spectators, and so you will probably never have a chance to actually witness a trial in the U.S. Supreme Court chamber. Branches of government. Article I establishes the legislative branch, the Congress, that makes the laws. Article II is the executive branch, led by the president, that enforces the laws. And Article III is the judicial branch, headed by the Supreme Court, that interprets the laws. What do they mean? So judicial review. The Supreme Court has the power to review the constitutionality of acts of the national and state governments. Judicial supremacy. The idea that the Supreme Court is the final voice on questions of whether actions by the national government or state governments are constitutional. And what they say is the final statement on a law. Now, if somebody doesn't like what the Supreme Court has done, then the remedy is to pass a new law on that particular subject. But until a new law is in place, whatever they have said is the law. Article 3, Section 1. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judges both of the Supreme and inferior courts shall hold their offices during good behavior, and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. Congress controls the details of the national court system. Congress has considerable authority to change the size of the Supreme Court, and in the 19th century they changed it a number of times, adding and subtracting depending upon certain situations. 1869 they established it at 9, and it has stayed at 9 for 155 years. In 1937, President Roosevelt introduced the Judicial Procedures Reform Bill. That would have allowed the president to appoint an additional justice for every sitting justice who was over 70 years of age. That would have meant Roosevelt could add 6 of his own justices to the court. You see, the court had been overturning his New Deal, and he didn't like that. Unfortunately, or fortunately, there was a real reaction to this, and this measure did not pass, and that's why the court has stayed at 9. They also have the power to shape the jurisdiction of the federal courts. In other words, what cases federal judges can or must hear. To shape the details of the federal court system as a whole. In other words, how many federal judges, how many courts of appeals, how many district courts, and so judicial independence. Judicial independence is the idea that the federal courts must be independent from the control of the other branches. This is done by giving justices and judges life tenure and guaranteeing their salaries. Judges can only be removed through the impeachment and removal process, and as I pointed out, it's rarely done. Article 3. Now, this is a detailing of all of the different kinds of cases where the judicial powers shall extend in law and equity. However, I'm not going to read all of this. Simply know that it pretty much covers almost anything that you can think of. And in Section 2, it is in all cases affecting ambassadors, other public ministers, and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. This is where the action actually begins with them and it ends with them. It's not an appeal. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. The trial of all crimes, except in cases of impeachment, shall be by jury. And I will note that, yes, you always automatically are given a jury in any federal case, unless you request that it be just a judge and not a jury, but you have to make that request, and that does happen. Such trial shall be held in the state where the crimes have been committed, but when not committed within the state, the trial should be at such place or places as the Congress may by law have directed. So that's why the documents case is in Florida's court, because the crime allegedly took place in Florida. On the other hand, one of the crimes of January 6th, and the immunity case, that was in Washington, D.C., and so it's in that court. And then the hush money case is in New York, because that's where that crime allegedly took place. What sorts of cases can the federal courts hear? Cases that involve people from two different states, cases that involve the Constitution or a national law or regulation, cases where the court has original jurisdiction. Original jury in all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. Judiciary Act of 1925, called the Judges Bill. The bill, driven by Chief Justice Taft, gave the court broad control over the cases it heard. Before 1925, the court had very limited control over the cases that came before it, and it had to hear a ton of cases each term, and it no doubt would have been even worse today. Today, the Supreme Court often takes fewer than 100 cases in a single term, even settling in with a little over 60 in recent years. The big idea: the Constitution's Article 3 establishes national government's judicial branch, the federal judiciary, headed by a single Supreme Court. Within the national government, the judicial branch is responsible for interpreting the law. Importantly, the Constitution also promotes the principle of judicial independence, granting federal judges life tenure. Federal courts, including the Supreme Court, exercise the power of judicial review. This power gives the courts the authority to rule on the constitutionality of laws passed and actions taken by the elected branch. How does a case get to the Supreme Court? Well, I take a little side tour here of the emergency docket, sometimes called the shadow docket. Supreme Court's emergency docket, also known as the shadow docket, consists of applications seeking immediate action from the court. Unlike the merits docket, these cases are handled on an expedited basis with limited briefing and no oral arguments, and the court often resolves them in unsigned orders with little or no explanation. The shadow docket, or non-merits docket, refers to motions and orders in the Supreme Court in cases which have not yet reached final judgment, decision based on appeal and oral argument. This especially refers to stays and injunctions or preliminary relief, but also includes summary decisions and grant, vacate, remand orders. The phrase shadow docket was first used in this context fairly recently, in 2015, by University of Chicago law professor William Bowdy. Shadow docket is a break from ordinary procedure. Such cases receive very limited briefings and are typically decided a week or less after the application is filed. The process generally results in short, unsigned rulings. These are the kind of thing, for example, when a person is been given a death sentence and they are facing the execution at a certain fixed time. They may appeal under the shadow docket, and one judge might take action, or they may refer it to all of the judges. But it's an emergency that has to take place. It's used when the court believes the applicant will suffer irreparable harm if its request is not immediately granted. Historically, the shadow docket was rarely used for rulings of serious legal or political significance. However, since 2017, it has been increasingly used for consequential rulings, especially for requests by the Department of Justice for emergency stays of lower court rulings. Practice has been criticized for various reasons, including for bias, lack of transparency, and lack of accountability. For the shadow docket, following an application to the relevant circuit justice, they will decide whether to independently make a ruling, in other words, all alone, one justice, or refer it to their colleagues. And each justice handles certain circuits that are under their responsibility. Applications are dealt with on an accelerated time frame, with decisions coming in a week or less. Should a justice proceed alone, the parties in a case may request that other justices overrule them instead. According to the court, there are 4 criteria for stays to be granted: that there is a reasonable probability that 4 justices will grant certiorari or agree to review the merits of the case, that there is a fair prospect that a majority of the court will conclude upon review that the decision below on the merits was erroneous, that irreparable harm will result from the denial of the stay. Finally, in a close case, the court justice may find it appropriate to balance the equities by exploring the relative harms to the applicant and respondent, as well as the interests of the public at large. The term schedule. The court's term typically lasts from the first Monday of October to the end of June. The court sets oral arguments for cases which usually run through April and occur the first 2 weeks of each month. Opinions are released throughout the term, with the final opinions, often on the most important and controversial cases, coming in the end of June, although there's no deadline because the justices set their own docket and their own schedule. Remember, all of this is not in the Constitution itself, but the result of over 2 centuries of Supreme Court practice. How does a case get to the Supreme Court? Most constitutional cases start with a simple argument: the government has violated the Constitution. Someone, often a single, ordinary American, comes to court and argues that a law or arrest or regulation violates the Constitution. The Supreme Court receives about 10,000 petitions a year. The justices use the rule of 4 to decide if they will take the case. If 4 of the 9 justices feel the case has value, they will issue a writ of certiorari. When all is said and done, the Supreme Court will hear about 65 to 70 cases a year. What that tells us is that most petitions are denied. So appealing to the Supreme Court may sound good when you say it, but in the reality is it just doesn't happen. Then the district court. In nearly every case, someone brings a new case in what's called a district court. This is the lowest level of the court in the national court system, and there are 94 of them, as I mentioned before. This is where nearly every case starts, and frankly, where most of them end. They don't go any further than that. A single judge presides over or manages the case, and the case is decided by either a judge or, more often than not, by a jury, usually of 12 members. Someone wins and someone loses. Court of Appeals. The loser might decide to appeal or challenge the district court's ruling by having the next level of court, the Court of Appeals, take a look at the case. If someone appeals their case this court to this court, the judges have to decide it. Generally speaking, they have 2 options: say that the district court got it right, or say that the district court got it wrong, and then explain why and reach a new decision. And here's a map that shows where the 13 circuit courts of appeals exist, 12 geographic circuits, and then 1 for the Washington, D.C. area. Filing for cert. Finally, the loser in the Court of Appeals might try to get the Supreme Court to decide their case. They can petition for a writ of certiorari or file for cert. This simply means that the loser in the Court of Appeals wants the Supreme Court to take their case and decide it. Justices read the challenger's cert petition, asking the court to take the case. 4 of the 9 justices must vote to take the case. The rule of 4. When the court takes a case, we call that granting cert. The Supreme Court rejects nearly every petition. The court accepts only 60 to 100 of the more than 7 to 10,000 that's asked to review each year. Each side files briefs or little books that lawyers write presenting their constitutional argument. Others affected by the case can also write briefs, known as friends of the court or amicus briefs. The justices then read the briefs in the case, and they do pay attention to those as well, because they recognize that there are many people with many opinions that must be taken into consideration. Supreme Court holds oral arguments is when the lawyers on each side get to state their case and the justices get to ask questions, and they do ask pointed, probing questions. The Friday conference. The justices then get together once a week to discuss and vote on the cases. This is known as the Friday conference, and these conferences are held in secret, and there is no one else allowed in this room other than the 9 justices themselves. And there is a message coming in from the outside. If the door is knocked on, the person who has to go and answer the door is the most recently confirmed justice to the court. Opinion. In nearly every case, one justice writes a majority opinion, which has the support of a majority of the justices. Either the Chief Justice or the most senior justice in the majority will assign who writes the opinion. In some cases, one or more justices might write a dissenting opinion. And finally, one or more justices might write a concurring opinion, offering additional thoughts on the constitutional issue in the case. Announcement. After the justices finalize their votes and opinions in the case, the court's decision is then released to the public. How does a person become a Supreme Court justice? The President shall nominate, and by and with the advice and consent of the Senate shall appoint the judges of the Supreme Court. Nomination process. A seat on the Supreme Court opens up. Somebody resigns or someone dies. The President considers a number of potential people for the position, reading about them, asking for advice from others, interviewing potential choices, etc. The President selects someone. Now, there is already in advance many potential Supreme Court justices for the future have already been examined, and their background and so forth has already been compiled. And so the president has a ready list to look at when he's ready to consider that. That person, after they're nominated, then accepts the nomination. Confirmation. The Senate Judiciary Committee holds confirmation hearings during which senators ask the nominee questions, piercing questions. Judiciary Committee votes on whether to recommend confirmation to the rest of the Senate. The nomination is then sent to the full Senate, who debates the nominee and votes on his or her confirmation, yes or no. He or she wins Senate approval. He or she then becomes a Supreme Court justice. If not, and there have been cases where people have been nominated and then rejected, and so the whole process has to start all over again. All of this started at the Constitutional Convention, May to September 1787 in Philadelphia. Judiciaries in early America. Many early state constitutions were radical in their embrace of legislative supremacy. And under the Articles of Confederation, our nation's first framework of government, there was no separate national court system. Critics, including Thomas Jefferson, John Adams, and James Madison, began calling for new checks on legislative power. By the 1780s, several state judiciaries, for instance, in New Jersey, Virginia, New York, Rhode Island, and North Carolina, began experimenting with judicial review. Still, for many early Americans, vesting judges with the authority to declare laws unconstitutional was considered unwise. As late as 1787, John Dickinson still could say of judicial review that no such power ought to exist. Delegates spent little time discussing the federal judiciary or the issue of judicial review. They were so concentrated on what the Congress should do and what the president should do that they left the judiciary to the last minute in their deliberations. But many delegates assumed that the federal judiciary would exercise judicial review in some form. James Madison, among others, looked for a variety of ways to curb legislative power. On the one hand, many had grown worried about legislative supremacy and thought that an independent judiciary would help check the excesses of Congress, and they knew there would be excesses. Furthermore, proponents of a fairly strong judiciary valued a federal judiciary's ability to settle certain constitutional issues, promote the uniform application of national law, and check an abusive Congress and the president. And it can happen, and we've seen it, and I won't even have to tell you when and where and how. And promote the idea of the Constitution as the supreme law of the land, created by the people, not Congress, and enforcing the fundamental law over ordinary laws passed by Congress. So debates, on the other hand, many of the founding generation also thought judicial review, even if permitted, should rarely be exercised, and that the judiciary should normally defer to the popularly elected branches. And critics of a stronger federal judiciary argued that judicial review was in tension with democracy. They feared that the federal judiciary and judicial review itself might help usher in an aristocratic national government, one that would grow strong by taking powers away from the states and the people and consolidating all political power at the national level. Federalist number 78 speaks to this issue. That's written by Alexander Hamilton in May of 1788. In Federalist number 78, Hamilton famously defined the judiciary as the weakest of the three branches, but he also emphasized the importance of judicial review and an independent judiciary to our constitutional system as a whole. Hamilton emphasized the duty of the courts to declare all acts contrary to the manifest tenor of the Constitution void. The interpretation of the laws is the proper and peculiar province of the court. A constitution is, in fact, and must be regarded by the judges as the fundamental law. It therefore belongs to them to ascertain its meaning as well as the meaning of any particular act proceeding from the legislative body. There is no position which depends on clearer principles than every act of a delegated authority contrary to the tenor of the commission under which it's exercised is void. No legislative act, therefore, contrary to the Constitution can be valid. Repeat that one. No legislative act, therefore, contrary to the Constitution can be valid. In Hamilton's view, the elected branches may claim to speak for we the people, but no branch of government speaks as the perfect voice of the American people. Only the Constitution itself is an authentic expression of the American people's voice. The Constitution itself, its very legitimacy, is rooted in popular sovereignty. And Article 6, the Supremacy Clause, makes it the supreme law of the land. So the federal judiciary has a special duty to heed the people's commands and protect their rights, sometimes using judicial review to check the actions of the elected branch. At the same time, Hamilton argued that the federal judiciary should be the weakest branch of government. In a government in which they are separated from each other, the judiciary, from the nature of its functions, will always be the least dangerous to the political rights of the Constitution, because it will be the least in a capacity to annoy or injure them. The executive not only dispenses the honors, but holds the sword of the community. The legislature not only commands the purse, but prescribes the rules by which the duties and rights of every citizen are to be regulated. The judiciary, on the contrary, has no influence over either the sword or the purse, no direction either of the strength or the wealth of the society, and can take no active resolution whatever. The judiciary, on the contrary, has no influence over either the sword or the purse, no direction either of the strength or the wealth of the society, and can take no active resolution whatever. It may be truly said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm, even for the efficacy of its judgments. Early Supreme Court. Supreme Court was in the basement of the Congress. It didn't have a very good place to meet. The justices lived together in cramped spaces for the brief periods in which the court met, and otherwise the justices rode circuit, meaning that each justice was assigned to oversee a federal circuit and literally had to ride out to it to attend a court session. So they were having to move, and it was not a very comfortable thing to do. The first Chief Justice was John Jay, And he said that he preferred being governor of New York to being Chief Justice of the United States. Judiciary Act of 1789 created the federal court system itself, the system of circuit riding, the various judicial districts, the office of the Attorney General, the offices of the U.S. attorneys and U.S. marshals in each judicial district, and finally the Supreme Court itself with the 6 justices, 1 Chief Justice, and 5 Associate Justices. I have to mention this important case, Marbury versus Madison in 1803. Big idea. Chief Justice John Marshall established the power of judicial review by giving the reasons the court can strike down acts of Congress. Players, in this case, were outgoing President John Adams, incoming President Thomas Jefferson, John Marbury, and James Madison. Before leaving office, after losing an election to Thomas Jefferson, President John Adams appointed a man named William Marbury to serve as a justice of the peace. Marbury's commission was signed and sealed by President Adams, but it was never delivered to Marbury. When Jefferson became president, he ordered his Secretary of State, James Madison, to not deliver the commission. Marbury brought a lawsuit to compel Madison to deliver his commission. He asked the Supreme Court to issue a writ of mandamus. That mandamus means it must happen. This was an order directing Madison, but really Jefferson, to carry out his lawful and non-discretionary duty to deliver Marbury's commission. The Supreme Court got this power from the Judiciary Act of 1789. John Marshall wrote the Supreme Court's opinion in Marbury for a unanimous court. As to this specific case, the court exercised the power of judicial review and declared the relevant part of the Judiciary Act unconstitutional. Marshall concluded that the Supreme Court did not have the power to force Madison to deliver Marbury his commission. For that, first, that by signing the commission of the Mr. Marbury, President Adams appointed him a Justice of Peace for D.C. This gave Marbury a legal right to the office for 5 years. Second, that having the legal title to his office, Marbury also had a right to the commission, and the refusal to deliver him was a plain violation of that right. Third, that Marbury was entitled to the remedy for which he applies. He should get the job. However, fourth, and finally, the Supreme Court didn't have the power to provide that remedy. The court itself didn't have the power to give him the job. Marshall said that Marbury clearly has the right to the commission and to hold office. Marshall also denies that the Supreme Court itself has the power to act because the relevant part of the Judiciary Act is unconstitutional. This permits Marshall to exercise the power of judicial review, establishing an important precedent. It is emphatically the province and duty of the judicial embarkment to say what the law is. And so we have this whole discussion, and that is the end for today. But as you know, that is until the next story. So we look forward to you joining us when we explore something else in even more depth next time. Thank you much for being with us. Really appreciate it if you would hit the subscribe and the like buttons down below, because that gives me an incentive to produce more programs just for you.